Yes, good evening to everybody. Welcome to the today class. And today that I am going to make it the audacious liability of the state, or the state liability, or we can say the vicarious liability of the state. So this topic, I am very much interested topic. Then I will show you why this topic is very much interest to me. Okay, read what is posted on the screen. Anyone? Unmute and read. Anyone can unmute and read.
State liability for torts. Professor. Sir, convert please.
Professor?
Professor Dr. Mohammed Saheb Hussain.
Yes, yes. What about this one? Read.
Good evening to the legal fraternity, vicarious liability of the state. At common law, the crown could not be sued in torts.
Either
Sir, convert please. Sir.
either for wrong actually authorized by it or committed by its servants in the course of their employment. Professor Dr. Mohammed Saheb Hussain. Sir.
Yes, this topic is very interesting topic to me because
Vicarious liability.
what I shown on the screen.
Usmania University, Hyderabad, TS, India, 1992 to 1995. PhD
You have
in law,
PhD.
30 years liability of state in India.
That is the reason I can say at least 1 week also on this topic. This is my
PhD.
PhD
Topic.
topic. That's I want to show you. Yes. Now let us see in short, tortious liability of the state means civil liability of the state, how it can be there. The concept of the tortious liability of the state means the state is liable for the acts of its servants. State has to act through the human agency in carrying out the various functions. So the important question which arises whether the state can be held vicariously liable for the acts of its employees or not. Under the English law, the old position was that Crown enjoyed the immunity from the wrongs committed in tort. Earlier days, there are no courts. What are there? There are no courts earlier days. Then how the administration of justice could be disposed? If you know it, you tell me. If you don't know it, you say pass on.
Pass on,
Under
sir.
the king rule, sir.
See, at the time, kings used to sit. There is a darbar, Diwani, Adalat would be there. So they used to sit over there. Sometimes the civil cases, sometimes the criminal cases. So king is the crown, is the justice, the fountainers of justice. So here crown could not be sued for the tort of its servants at the time because there is a saying is there, king can do no wrong. That's largely based on the concept, king can do no wrong. Its Latin terminology is rex non potest peccare. I already told you what is rex. What is rex?
Pass on.
Pass on, sir.
Ayyo, naina ni dandam pedta. Rex means I told in my earlier classes king or represented by shortening form or initialism. And the queen, what do you say queen in Latin? Queen. If you know it, you tell me. If you don't know it,
Pass on.
pass on. Anyone? Say pass on.
Pass on, sir.
Regina. R-E-G-I-N-A. Be careful in the spelling. R-E-G-I-N-A. I told you also, and I have shown you, again you are making the same thing. It's a shock to me. See, I have shown on the Google also. Rex means, what is there? Rex means the reigning king used following the name in the title of the lawsuit Rex versus zones. R versus Abdullah. R stands for Rex. Rex stands for
King.
Queen. Then I already told you the Regina. Regina. Regina means, see here I have shown the Regina, the reigning queen, used following the name in the title, lawsuit. Regina versus Jones. So I told you, Rex means king, Regina means king. So in the olden times, used to the Rex means king, non-potest peccare. That means king can do no wrong. That is the concept. With the increasing of the government function, this concept was abolished with the Crown Proceeding Act 1947 of in the UK, in the Britain. There is a special act is there, Crown Proceeding Act. In the USA, there is another act is there, US Federal Claims Tort Act in the USA. But India, the first law commission made that there should be a legislation where the state will be held liable. In 1956, if I have not been mistaken, the first law commission. And till today, there is no law on the state liability. Do you know why? Do you know why? Because if the law is there, then everybody can make it out. And the first law commission, it is categorically say that there should be first law commission in the year. I think it is 1956 or 55 in the year. See, I kept it high. That's why I could not type it properly. No, this is 1834. No. The first law commission, there they made this, the first law commission, yeah, unit 4, first law commission, it is given. So in the provisions of the first law commission, they made it, there should be a state liability codification in the law of tort also. So till today, it is not materialized. So now what I want to say is, there is a legislation in the UK. There is a Crown Proceeding Act 1947. There is a legislation in the USA, Federal Tort Claims, of course 46, that is 1946 if I not be mistaken. And till today there is no legislation. The act treated the government in the same position as the subject. As far the India position is concerned, doctrine of king can do no wrong was never accepted in India. Liability of the government is fixed under the Article 300 of the Constitution, where it can say Union of India. And the state can be sued in the same way as the Dominion of India and the provinces before the commencement of the Constitution. In order to effectively appreciate the concept of tortious liability of the state, the concept of sovereign and non-sovereign function is to be understood. Earlier times we will say that sovereign function, non-sovereign function. Of course, the gap is narrowed down now in the present situation. Sovereign function means that functions which could be done only by the state. What is that function which can be done only by the state? Anyone? Anyone? What is those functions which can be done only by the state? If you know it, you tell me. If you don't know it, say, pass on.
Sir.
Pass on, sir.
Defense, railway, of course they are going to give you soon. Postal, police, minting currency, foreign external affairs, air force, navy, military, army. So certain function only the state could do it. Other function, now the state is it became from the laissez-faire to the welfare state. I think, yes, welfare state when it's come over there, the state can doing the business also. See, Telangana House Board Corporation is there. Is there or not? Housing Corporation. House Board is there or not? I don't know why you are keeping quiet. Bhaktullara, are you hearing me? ఆర్
Yes,
యూ
sir.
హియరింగ్ మీ? అయ్యా నా
Yes, sir.
నోరంతా పోతుంది కాదండి, చెప్పరాదండి సార్. తెలుసు
Yes, sir.
తెలియదండి చెప్పండి, తెలిసిందని చెప్పండి. సో నా ద స్టేట్ డూయింగ్ ద ట్రేడింగ్ బిజినెస్. ఇంతకుముందు ఉండేది ఏంది? విజయపాలు. ఎవరి అండి విజయపాలు?
Pass on, sir.
నాయను. ఇంతకుముందు ఏపీ డైరీ డెవలప్మెంట్ కార్పొరేషన్ ఉండేది, తర్వాత తెలంగాణ డైరీ డెవలప్మెంట్ కార్పొరేషన్ అయింది. అది విజయ్ డైరీ చూసారండి? హెడ్ క్వార్టర్ ఎక్కడుంది విజయ్ డైరీ? లాలాగూడ. ఇజ్ ఇట్ ఆర్
Okay,
నాట్?
sir.
ఇది చెప్పండి సార్.
Yes, sir. Yes, sir.
అది అట్లా చెప్పాలా, నాకు రావాలా ఆన్సర్, రావాలా నాకు అట్లకెళ్ళి. మళ్ళీ ముల్కనూరు
Okay,
ఎక్కడ
sir.
ఉన్నదండి?
Mulkanur, Warangal, sir. Telangana.
వరంగల్
భీమదేవరపల్లి.
కరీంనగర్లో ఉన్నదా?
భీమదేవరపల్లి.
Okay. So what I want to say is, now the state is doing the commercial function, state is doing the building construction, state is doing the trading construction because of the social welfare state. So state doesn't have the immunity in the non-sovereign function. State is having the immunity in the sovereign function. So now let us see what is the sovereign and what is the non-sovereign function. When East India Company arrived in India, it was essentially a trading entity. East India Company, ఎక్కడికి వచ్చిందండి ఈస్ట్ ఇండియా కంపెనీ?
ఇండియా.
సార్ మా ఇంటికి వచ్చింది సార్.
ఇండియాకి సార్.
ఎక్కడికి వచ్చింది?
ఇండియా. ఇండియా.
ఇండియాకి వచ్చింది. అదే అంటే ఎక్కడ అంటే అది
కాలికట్.
కే సముద్రంకి వచ్చిందా, గార్లకు వచ్చిందా, డోర్నకల్కి వచ్చిందా?
East side of India, sir.
కల్కత్తాకి వచ్చింది.
సార్ కాలికట్. కలకత్తా.
కల్కత్తా. So East India Company has reached to the Calcutta and built the trading business. The purpose of the company was to trade in India. Subsequently, it obtained the Diwani rights from Mughals. Trading ka change చేసిందండి, ప్రభుత్వం చేసింది మన మీద. They rule also. Mughals were acquired the dual characteristic at the time. Trading company became a sovereign also. Later, the company was granted the right to acquire the territory and maintain the army on behalf of the crown, because dividend rule policy they made it, and they captured the entire
State.
India except
Hyderabad state.
Nizam state. Later on they take
Yes, sir.
that.
Yes, sir.
కదా.
Operation Polo.
They invaded the even Nizam state also. Okay. So now, by virtue of the
Okay,
government of India, 1858, the crown took the sovereignty from the company. Then after the 1915 government of India act was there, and our constitution is totally based on, our present constitution is totally based on, maximum based on government of India act of what? It is 1858 or 1915 or 1935? 1935. Our present constitution of India is based solely on government of India act of 1935. Because of the dual characteristics of East India Company there was a distinction between the sovereign and non-sovereign functions. The first and foremost cast law, if you read the state liability, అసలు చదివినం అంటే ఈ 3 or 4 కేసుల, it should be on your tip of your tongue. At least 4 to 5 కేసుల, it should be tip of your tongue. Number 1, P&O Steam Navigational Company versus Secretary of State. అప్పుడు సెక్రటరీ ఆఫ్ స్టేట్ అనేది. ఇప్పుడు ఏమంటామండి? స్టేట్ని సూ చేస్తే
Pass on, sir.
ఎస్, టెల్ మీ. పాసానా?
Yes, sir. Pass on, sir.
స్టేట్ ఆఫ్ తెలంగాణ అంటాం స్టేట్ని సూ చేస్తే. ఇండియాని సూ చేస్తే
Union of
Government of
India.
India.
యూనియన్ ఆఫ్
Union
ఇండియా
of
అంటాం. బట్ ఎట్ ద టైమ్ సెక్రటరీ ఆఫ్ స్టేట్ అంటాం if you want to sue the state. So in this case, what happened? Court held that the particular act can be done by the private person, that it does not qualify the sovereign function. In case law, if you read the facts of the case law, see, there is a dockyard is there, Kodaluru dockyard, if I not be mistaken, in the Calcutta, where the ship repairs on ship construction is going on, ship repairs are going on, commercial transaction is going on over there. from the backyard, there is a horse-drawn cart also going by the side. But the people, they are carrying the iron bars, iron rods, iron shafts. So when they are dumping, when they are making down, they are throwing from the shoulder directly on the earth. So there is another iron shaft was there, and because the steel rod or the iron rod fell on the another iron rod, then what type of the sound will come? What type
Ton
of
ton sound, sir.
huh?
Ton ton sound, sir.
Yes, a sound was produced over there, and that sound startled the horse, and the horse got injured because it run from one place to another place where the rods were there, so got injured over there. So consequently, it died also. So the horse-drawn cart owner filed a case against the company. Of course, the company is giving the way to pass on from the yard to other places. It is not thoroughfare, no, it is a thoroughfare. ఇది రహదారి కాదు. ఇంగ్లీష్లో చెప్పండి. ఇంగ్లీష్లో చెప్పండి.
Highway.
Not highway.
This is
Yeah,
not
side.
way.
ఇందాకనే చెప్పిన నేనే చెప్పిన కదండి, ఇట్ ఈస్ నాట్ ఏ థరోఫేర్ అని. No thoroughfare. Okay. So it is the carts are passing over there, but the got injury. Which one injury? The defense taken by the government is sovereign function. They say if the dockyard repair, it can be done by any individual also. Not a sovereign should have to do the dockyard repair or the repair in the dockyard. You can give to a private company also. So they said a thing which can be done by the private individual, then we cannot assign the sovereign function, because sovereign function, just now I told you. What is the sovereign functions? What are the sovereign functions?
Defense.
Defense,
Manufacturing
right,
units.
coinage,
అయిపోయినాయి.
Defense. Transport.
I told it is 6 or 7. రైల్వే అన్నాను, దెన్ పోస్టల్ అన్నాను నేను, డిఫెన్స్
Police.
3 డిఫెన్స్లు అన్నాను నేను, 3
sir,
డిఫెన్సెస్.
FIs, postal, police, currency, airports,
కరెన్సీ అన్నాను
military,
నేను,
army,
పోలీస్ అన్నాను నేను.
army.
Yes. So that only that. So here, making the repairs in the dockyard is not a sovereign function. Hence, he should be Secretary of State is held liable in this case law. Secretary of the State is. So what the court classified the acts of the Secretary of State in sovereign function and non-sovereign function. The court clarified that in respect of a sovereign function, Secretary of State was not liable, but this observation was, court was followed to the catena. Catena means? Catena means? Catena means?
A connected series of related things.
బ్రాకెట్లో పెట్టాను కదండి. A connected series of related things of decisions. There are many decisions are there. Suppose if a military car or a lorry taking the jawans for the market, is it a sovereign function?
No, sir.
The military truck going to the Monda market to purchase the vegetables, is it a sovereign function? Answer no.
No,
If the
sir.
military truck is going on the war side to face the war, taking the jawans to the war side, yes, it is a military sovereign function. Okay. Say
Yes, sir.
Okay. Now read anyone, Nobin Chandar. You read this case. Anyone unmute and read.
In Nobin Chandar Day versus Secretary of State for India, plaintiff applied for a license of ganja shop and he deposited certain amount. The license was denied. He sued the state for refund of amount and claimed damages. Court held that the grant of license of run ganja shop was a sovereign function and action was not maintainable.
గాంజా దొరుకుతుందా అండి మనకు?
No, sir.
సార్ దొరుకుతుంది సార్, నర్సం పెట్టిపోతే.
దొరుకుతుంది సార్.
Illegal గా దొరుకుతుంది.
You cannot sell the ganja in the open market. It can only be grown by the government. Karwan ఉన్నది చూసారండి హైదరాబాద్లో? It will be grown by only the government, some herbal plants over there. And the government only having the license to grow such a thing. Or they give the license to the other people to grow it, but they have to sell only to the government. Because from there the medical, the psychopathic substances are manufactured. So they said, okay, we are going to sell the ganja and we'll give the license to you. But later on, they say, no, we are not supposed to give the ganja license to the individual. So they cancelled it. But in the beginning, they gave it. But later on, they cancelled it. The plaintiff applied for the license for the ganja shop and deposited certain amount. The nominal amount is there for the making the entry registration. So the license was denied, sued the state for the refund of the amount and claimed damages. Court held that grant of license is a run ganja shop was a sovereign function and the action was not maintainable. Sir, mali mari ichina was sir adi registration charges. Registration charges are not refundable. Are you following me?
Yes, sir.
Yes, sir.
Yes, very good. Now, number 1, P&O Navigational Company means Peninsular Oriental Steam Navigation Company. P&O Steam Navigational Company, the first and foremost case law where the Secretary of State is sued. So what happened in this case law? What happened in this case law? Secretary of State is liable or not liable?
Not liable, sir.
Liable, because dockyard repair can be given to the individual also, and hence the Secretary of State is liable. It is not a sovereign function. Repairing is not a sovereign function, hence Secretary of State is liable. Nobin Chandra, ganja.
Yes, sir. The state is liable.
Sovereign power is there, so they can take the advantage of the sovereign function. So the government is liable or not liable?
Liable, sir.
Liable, sir.
Not liable. ఎందుకు? సౌరిన్ ఫంక్షన్ కాబట్టి. పైన అది సౌరిన్ ఫంక్షన్ కాదు, అది డాక్యార్డ్ రిపేర్ ఇస్ నాట్ ఏ సౌరిన్ ఫంక్షన్. హెన్స్ సెక్రటరీ ఆఫ్ స్టేట్ ఇస్ హెల్డ్ లయబుల్. ఇక్కడ ganja license, ganja growing is only by the state can do.
State.
So only the state sovereign function. So government is not
Liable.
liable. ఇక్కడ మళ్ళీ ఫస్ట్ అండ్ ఫార్మోస్ట్ కేసులో ఆఫ్టర్ ద ఇండిపెండెన్స్ అయిన తర్వాత స్టేట్ ఆఫ్ రాజస్థాన్ వర్సెస్ విద్యావతి 1962 కేసులో సుప్రీం కోర్ట్. ఇన్ దిస్ కేస్ ఏ జీప్ తెలుసా అండి మీకు? ఇంతకుముందు తహసీల్దార్ ఉండేది జీప్.
తెలుసు సార్.
ఇప్పుడు ఉన్నాయండి జీప్?
కనబడుతుంది సార్ అప్పుడప్పుడు రోడ్ల మీద.
లేవు. Of course, now certain things, the Jeep now Mahindra has taken. I don't know who has taken the Jeep, but the Jeep you could
Mahindra
see.
company, sir.
Mahindra, sir. Mahindra.
But only I saw some Jeeps which is go for the hunting Jeep చూసాను నేను. The lights are on the upper side. So Jeep was owned by the state of Rajasthan for official use for the collector. అప్పుడు జీప్ ఉండేది కలెక్టర్ కి. So what happened? The driver of the Jeep, while bringing the Jeep back from the workshop, అంటే ఎక్కడికి తీసుకెళ్ళి గ్యారేజ్కి తీసుకెళ్ళిండు. గ్యారేజ్కి తీసుకెళ్ళి ఏం చేసిండు? ఆఫ్టర్ ద రిపేర్ he is bringing back from the workshop to the collector office, but he negligently injured a pedestrian on the way and who subsequently died. So can you say it is a sovereign function? Taking the Jeep from the garage, coming to the collector office is a sovereign function?
Yes, sir. Sir, no, sir. Sorry.
It is not a sovereign function. The court held that state vicariously liable for the rash and negligent act of the driver and Supreme Court rejected the notion that king can do no wrong. They stated that such a notion is not applicable in India, keeping in mind the socialistic pattern of the society. A large number of the function of the government state should be held vicariously liable for the tortious act of his servant. Because if the collector is going for the any emergency work like I don't know, collector is not exempted generally because when he wants to use it, yes, he has to do care. But if the ambulance made the injury, okay, not liable. Are you following me?
Yes, sir.
Yes, sir.
If the fire brigade kills the person, because fire brigade, how many hands are there? పెద్ద గంట ఉంటుంది తెలుసా అండి ఫైర్ బ్రిగేడ్కి.
Yes, sir.
Yes, sir.
ఆ గంట కొడితే దాదాపు 3 kilometers వరకు వినబడుతుంది. So fire brigade, if they made with an accident, no, you are not going to get it because they do have the immunity. Even a red light is there, doesn't matter, the fire brigade will go. Even a red light is there, the ambulance will go. Did you observe?
Yes, sir.
Yes, paka this petester. If the ambulance or the fire brigade is going over there. If not, if you die or if you got injured, you are not going to get anything. So you should come aside when the bell rings over there. Sir, నాకు వినబడలేదు సార్ అన్నా. అంత పెద్ద బెల్ 3 kilometers వెళ్ళి పర్సన్ కెన్ హియర్ అండ్ యూ కుడ్ నాట్ హియర్. సార్ నేను మ్యూజిక్ వింటాను సార్ అప్పుడు. ఈజ్ ఇట్ యువర్ ఫాల్ట్ ఆర్ మ్యూజిక్ ఫాల్ట్ ఆర్ ఎనీబడీస్ ఫాల్ట్? యు ఆర్ ఎ నెగ్లిజెంట్.
Our fault.
You are a negligent. Why do you enjoy the music when you are driving the vehicle or walking on the road? Okay, now Kasturilal Ralia Ram Jain, state of UP. This case I discussed a little. ఎవరండినే బంగారం ఆయనే బంగారం చేసేటోళ్ళని ఏమంటారండి?
Goldsmith, sir.
Goldsmith, sir.
గోల్డ్ స్మిత్ అంటారు. మరి కంచరోళ్ళని ఏమంటారండి?
Fabricators.
ఈ సబ్బళ్ళు చేసేటోళ్ళను క్రోబార్, యాక్స్, సికిల్,
Blacksmith.
blacksmith. Okay. So now this goldsmith in the market, he is going to say somebody has suspected it. He told, sir, I am the goldsmith merchant and I do have the license also. But they have seized all the gold ornaments and silver ornaments. And one of the policemen took the gold ornaments and he fled to the Pakistan. And they say, running the police department and keeping the hard cash room, keeping the persons in the custody in the police department is a sovereign function. So they say state is not liable. Kasturilal case, they say it's a sovereign function. ఇప్పుడు కంచెనే చేను వేస్తే చేనుకి ఎవరు కావాలండి? ఇంగ్లీష్లో చెప్పండి. సే ఇన్ ఇంగ్లీష్. సే ఇన్ ఇంగ్లీష్. పాస్ అని చెప్పరాదండి, ఎందుకు భయపడతాను?
Pass time, sir.
మీకు ఆయుధం ఇచ్చాను కదా ఒకటి.
ఆల్రెడీ ఇదివరకు చెప్పారు సార్, ఇది అది గుర్తు రావట్లేదు.
The purpose and I asking is read, recite and review. That is my
Triple R.
purpose. So otherwise you cannot remember the thing if I don't ask you. If the fencing itself eats the crop, who will fence the crop? Is it correct? Say yes.
Yes, sir.
Very good, I appreciate. So they say the Kasturilal case is later on bypassed. They said no, it is not a good law because it is the police who has to seize the property, should not keep in a custody, but they should not, somebody stolen away, and that to be a policeman. And again they say it's a sovereign function. They say in this case law they allowed it, but later in all the other case law they bypassed the judgment of
Kasturilal
రాలియా రామ్ జైన్. ఇక రాలియా రామ్ జైన్ ఏం గుర్తుపెట్టుకుంటారు కానీ కస్తూరి లాల్ గుర్తుపెట్టుకుంటారు.
Versus state of UP.
Thank you
Kasturi
so
Lal
much, sir.
versus state of UP. At least you remember this thing. That is more than enough. Kani, P&O Navigational Company, first case law Secretary of State, you have to remember. And the another Vidyavati. Which Vidyavati? State of
State of Rajasthan.
State of
Rajasthan.
Rajasthan versus Vidyavati, 1962 case law, you have to remember. Kasturi Lal versus State of UP, 1965 case law, you have to remember. Sir, ఈ ఇయర్లు కూడా సార్ మెమరీలో పెట్టుకోవాలా నేను చెప్తాను సీక్వెన్స్ చెప్తాను మీకు ఐఎమ్ గివింగ్ ద సీక్వెన్స్ పిఎం నావిగేషన్ 1865 case law, old case law. Later on 1962 case law is the state of Rajasthan versus Vidyavati. Next the Kasturi Lal versus state of UP is the 1965 case law. But later on all the other cases where the when a state can do when an individual can do a work, then that is not a sovereign function. When an individual cannot do such a work, then it is a sovereign function. In the sovereign function, state is not liable. In the non-sovereign function, state is liable like an individual. So Nagendra Rao versus state of Andhra Pradesh, in Nagendra Rao versus state of Andhra Pradesh, in Nagendra Rao case was state seized certain goods under the Essential Commodities Act. Nagendrarao కొంతకన్నా ఉన్నది నాగేశ్వరరావు నాగేంద్రరావు అనుకుంటా దే సీజ్ సమ్ ఎసెన్షియల్ కమోడిటీ గూడ్స్ బై ద కలెక్టర్ ఆర్ బై ద who is the person who is the food inspector. Are you following me?
Yes, sir.
Yes, sir.
So the state, to ensure that the said goods are carefully preserved in necessity, that the state was held liable to pay the compensation for the loss incurred. Suppose if the state has seized some essential commodities, if the from there, if somebody stolen over there, it's the state responsibility. The state should have to
Yes, sir.
give back the essential commodity to him. If they seized it, if it is wrong, okay, they can seize you. If it is not wrong, then you have to return it. So from there, somebody has stolen it, but the state should be liable if the property is stolen from there, which is seized. So in all other cases, they say the Kasturi Lal is bypassed. Is Jadani Challa Ramkonda Reddy versus State of AP? Very famous case law this is. Read this case law.
In the judgment of the High Court of Andhra Pradesh is Challa Ramakonda Reddy versus State of AP. It was held that the play of sovereign immunity was not available, where there was a violation of the fundamental rights of the citizens. It was a case where a person arrested by the police was lodged in the cell in the jail. He expressed his apprehension to the authority in charge of the jail that his enemies were likely to attack and kill him in the jail. This apprehensions was not given any consideration by the authorities. During the particular night, there were only 2 persons guarding the jail. Instead of the usual 6, the enemies of the arrested person entered the jail during the night and shot him dead. The legal representatives of the deceased filed a suit for damages. The trial court found that the authorities were negligent in guarding the jail and that the death of the deceased was attributable to such negligence. However, the suit was dismissed on the ground that the arrest and detention of the deceased in jail was in exercise of sovereign functions of the state. During the hearing of the plaintiff's appeal, the state relied upon the decision of the Supreme Court in Kasturi Lal. The High Court, however, held that where the fundamental rights of the citizens are violated, the play of sovereign immunity, which is assumed to be continued by Article 300 of the Constitution, cannot be put forward. This view has been approved by the Supreme Court in AIR 2000, Supreme Court 2083, State of AP versus Chella Ramakrishna Reddy.
Yes. See, the appeal from the High Court, it has gone to the Supreme Court. In the High Court, they have taken the decision of the Kasturi Lal. Okay, you can detain a person, no doubt. It is a sovereign function. But you see that his safety is more important. Because this person who was arrested, he told, sir, the enemies are more and they can hurl the bombs on me. They will shoot at me and they do at me. Please, sir, take care of me. Instead of 6 constables will be there who should supposed to guard the jail, there are only 2 are there because it is very common in the Kadpa Karnool. They will prepare the hand bombs like they are preparing the samosas. Are you following me?
Yes, sir.
Yes, sir.
Yes. Everybody knows art. Prepare like everybody knows samosa preparation. So they know how to prepare the grenades, hand bombs, shells, and I don't know how many people are having the even a pistol or something also. Because that is very much people say, and it's a true also what I heard. So anyway, that what I want to say, no doubt you can, sovereign function is there, you can arrest it, keep it in the jail, it is sovereign function, but the security of a person also very important factor. When an arrested person already told him that, sir, there are many enemies are there in my area, they can hurl the bombs in the cell and I can easily die. But instead of his apprehension, he showed the apprehension that he is going to be killed. So, but instead of the state did not take the heed of it. Hence, the sovereign function cannot be entertained by the state in the state of AP versus Challa Ramakrishna Reddy case. So now let us see the another very famous case law you would have seen in the newspaper also. Vadodara Municipal Corporation versus Purushottam V. Murjani. Vadodara Municipal Corporation versus Purushottam V. Murjani case law. The Supreme Court considered whether the municipal corporation, which was responsible for the management of the Sursagar Lake and was liable to pay the compensation under the Consumer Protection Act of 1986 for the death of the 22 persons who drowned in the lake during the boat ride due to the negligence of the plying the boat. You know the boat ride? Jai boat ride.
Yes, sir.
If you go to the Hussain Sagar, there is a boat ride is there. To take where? To take where?
Pasan, sir.
Near Buddha statue.
Buddha statue.
Buddha statue, sir.
They take you the Buddha statue, then after some times again you can come back, also you reach to the destination. If the Buddha, the ride, the joy ride is there, at the time the boat becomes topsy-turvy. What become?
Upside down, sir.
Upside down. Professor Hussain students say what?
Topsy turvy.
Topsy-turvy. T-O-P-S-Y, topsy hyphen turvy. T-O-R-V-E-Y, turvy. So they say if the municipal corporation is held liable because the joy riding is given for the tender to the somebody else. Then the principal is municipal corporation and the agent is the tendered person who got the tender. While holding the municipal corporation vicariously liable, the court did not rely upon the Kasturi Lal case law. No, Kasturi Lal case law will not be applicable over here. And Nagendra Rao case also they have taken the defense. Yes, municipal, because we should not say it is a sovereign function. Running the boat for the joy riding is not a sovereign function. It can be done by the individual because you have given that function to the agent by making the tender. At that instance, the municipal corporation is held liable to pay the compensation because under a vicarious liability, principal and agent. No, somebody did not, Sandhyarani, you did not keep it
Sir.
mute. You did not keep it mute because I'm getting the sound. Yeah, mute it. When you want to speak at the time, you can unmute it. So that is the case law where it can say there is the Vadodara Municipal Corporation versus Purushottam V. Murjani, that is the boat ride case law, that is the Sursagar Lake. So this is also one of the famous case law where we can make. But other case laws also there where the state is liable because that fellow is not going to attend the the legislative assembly sessions. In what is the name of the case law?
MLA versus
Jammu and Kashmir.
police
What is the
officer.
first name of the case? MLA.
Bhim Singh
MLA.
Bhim Singh versus State of Jammu and Kashmir.
Yes, I appreciate.
State of Jammu.
Yes, Bhim Singh versus state of Jammu and Kashmir, where the state is liable because of the police act, keeping him arrest without any justification. Later on, he was released, but his liberty is curtailed under the Article
17.
21. So there's another case law also I told you that comes under the conversion. They have taken the firewood from the adjacent land that belongs to another person, where the border security force, military people have taken. So military people, they did the conversion without the permission they have taken for cooking because their LPG is exhausted. What is this LPG?
Liquid petroleum gas.
Yes. So what is the name of the case law? Military comes under? Military comes under?
Pass on, sir.
State of Andhra
Pass on,
Pradesh,
sir.
sir. Military state of Andhra Pradesh వస్తుందా అండి?
Union of India, sir.
Union of India. Ruplal versus Union of India. That is another case law. The Union of India is liable because the border security force, they have collected the firewood from the adjacent land without the permission of them for the cooking purpose. So it is a conversion because fire is converted into, what is the fire into? Fire is converted into, firewood is converted into
Coal.
coal, charcoal anala. Better you can say coal because charcoal ఏమైందంటే they scientifically they burn the wood. The charcoal can be used by the
By the pass on, sir.
washerman for ironing,
Okay, sir.
even
yes,
for the
sir.
cooking. ఎక్కడ టు మేక్ ఇట్ హీట్ చార్కోల్ మీద పెడతారు చూడండి, ఏది రోస్ట్ చేయడానికి. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
Yes, sir.
Yes, sir.
బార్బెక్యూ చూసారు కదా, చార్కోల్ మీద పెడతారు. అంటే
Barbecue. Okay, sir. Okay, sir.
nowadays the electricity is there. బార్బెక్యూ. సార్ మా నోట్ల ఏమొచ్చినాయండి చెప్పంగానే? ఏమొచ్చిందండి నోట్ల?
Hotel.
Watering.
Saliva.
Saliva. SALIVA. Saliva used over there in the mouth. When you say, suppose if you take a good dishes, if the saliva will not come to your mouth, that means you are having some weakness. Are you following me?
Yes, sir.
Yes, sir.
So another case law also there. I don't know whether I taught you or not. Rudul Shah versus state of Bihar. Rudul Shah. వాడికి ఆల్రెడీ 14 years బిఫోర్ ఇచ్చేసిండ్రు. ఏది ఈజ్ ఎక్విటెడ్ అని. కానీ అది సర్వ్ కాలే వాళ్ళకు, అది ఎక్కడో పడేసిండు ఏది వీడు మెసెంజర్. దట్ ఫెలో ఈజ్ పుట్ అగైన్ 14 years ఇన్ ద జైల్. బట్ లేటర్ ఆన్ ద కోర్ట్ సెడ్ దట్ దిస్ మ్యాన్ ఈజ్ ఆల్రెడీ acquitted, but why did you keep in the jail for the 14 years? Actually, that is not served to him, or he misplaced it, or he overlooked it. He did not mention because he released somebody else except this fellow. So it is an inadvertent act of the jailer, and who negligently not released this fellow because he did not properly read the entire release order. So the state is held liable. Rudul Shah versus state of Bihar, where a prisoner which was released by the court because of his negligence, he could not read properly the entire judgment or entire letter. So he was failed to release this fellow. That fellow is put into the prison, but some activities found it. Then they will file a case against the state of Bihar for such a thing. Then state of Bihar is held liable to pay the compensation. So that is also very famous. Rudul Shah. Sebastian Hungary case law. This is another case law. Rudul Shah. నేనేం చెప్పానండి నేను? This topic is
liability of the state liability.
This topic is my PhD topic.
Yes, sir. Your PhD
Yes, sir.
topic.
Yes, sir.
లేదు అదే చెప్తాను మరి. The Rudul Shah case was a public interest litigation. The case filed in the Supreme Court under Article 32 of the Indian Constitution, where one can directly approach the Supreme Court when fundamental rights are being infringed upon. The government of Bihar agreed to make the payment. So that fellow is put behind the bar for 14 years in spite of his acquittal also. And hence, the case summary, see, the state of Bihar is held liable to pay the compensation in this case law. So facts of the case law, I told you. Arrested for the murder of the wife in 1953. He was acquitted in 1968 by the Court of Sessions, Muzaffarpur, Bihar, but was ordered to detain a prison till further orders of the state government and the IG prison. He was detained for more than 14 years prison. As a result, the petitioner filed a habeas corpus petition under Article 32 of the Constitution, paying of the release on the ground that his detention was jail was unlawful. So that was the thing. Issue is whether the Supreme Court can award the compensation under the Article 32 of the Indian Constitution for the breach of fundamental rights or not. Or does the Article 21 cover the right to compensation for the violation of the fundamental right? Yes, the Supreme Court say, in spite of his acquittal also, till he detained over there in the jail, and the 14 years his youth, he lost it, and the state is held liable to pay the compensation on the Article 821 because his liberty is curtailed for the 14 years. So it was observed that the right to life and the personal liberty, which is guaranteed under the Article 21, will be denuded if the significant content of the court's powers are limited to passing order to release from the illegal detention and was awarding the compensation in this case was necessary to secure the due compliance with the mandate of the Article 21. So this is also there. Another is case law is there. Railway Board versus Chandravati case law. The railway Nilayam at the Calcutta, the Bengali woman was there. So this fellow was taken to the railway Nilayam, they gang raped her. Then the railway company is held liable to pay the compensation. What is the name of the case law? Railway Board versus Railway
Chandravati.
I will tell you the case law name also. Chandrima Das. I will tell you. Railway Board versus Chandrima Das. Chandrima Kant. Chandrima Das. See, chairman of the Railway Board versus Mrs. Chandrima Das. And she is a Bengali lady. She came from the Bangladesh for the livelihood. And where the protection should be given for the women to each and everybody. So hence, the chairman, Railway Board and others versus Chandrima Das, Railway Board is held liable, even though the act which is done under the vicarious liability, even though it is a criminal act. Are you following me?
Yes, sir.
Yes, sir.
So there are
Yes,
so
sir.
many cases. Catena of decisions are there where the state is held liable to pay the compensation. Because only sovereign functions where the state is not liable. Suppose lathi charge చేసింది అనుకోండి మీ మీద. Can you go to the court? Can you go to the court?
No.
Because it is a sovereign function. Yeah, it is the Indian tradition that in the beginning or the ending of this any program that we will make the play of the national anthem. Now the national anthem will be.
विंध्य हिमाचल यमुना गंगा जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।
जय हिंद।